Welcome back to our channel RR Corporates. In today's video, we are diving into one of the most debated and legally complex intersections between two major corporate laws in India. One is the Companies Act 2013 and another is the Insolvency and Bankruptcy Code 2016. So the big question is here, does disqualification under section 164 2A of the Companies Act automatically disqualify someone from submitting a resolution plan under section 29A of the Companies Act under section 29A of IBC? This is the major question. So because this is the debate, major corporate laws in India, between the major corporate laws, that is Companies Act 2013 and IBC. So we'll see the background and the legal provisions. See, under IBC, the resolution applicant must meet eligibility norms. But there is an ambiguity when a person disqualified under Companies Act, especially for non-filing of annual returns or financials, tries to submit a resolution plan. Let's explore the two sections that cause the legal clash. One is section 164 2A of the Companies Act 2013. So what section 164 of Companies Act 2013 says is, if it starts with no person who is or has been a director of the company which has not filed financial statement or annual returns for any of continuous period of 3 financial years shall be eligible to be reappointed as a director. This is a disqualification. If the director not filed the company financial statements or annual returns with MCA, so this is a disqualification under 164 2A. And we also talk about another section 29A E of IBC. So section 29A E of IBC says a person shall not be eligible to submit resolution plan if such person is disqualified to act as a director under the Companies Act. So this 29A of IBC says that this person shall not be eligible to submit a resolution plan if such person disqualified to act as a director under Companies Act 2013. So here the question, does a disqualification under section 164 2A of Companies Act 2013 automatically trigger section 29A E under IBC? This is the big question. So the two judicial views, now we will see. The first view is no automatic disqualification. This is what Honorable Supreme Court said in the year 2023. In M.K. Rajagopalan versus Periasamy, Palani, Gounder, the Honorable Supreme Court ruled that disqualification under section 164 2A must be formally determined by a competent authority like ROC, Register of Companies. In the absence of valid disqualification, order, the DIN remaining active complaint so indicated that no official disqualification existed. Suppose even though the director has not filed financials annual returns for continuous period of 3 years, DIN is remaining active and there is no disqualification from Register of Companies, then no official disqualification existed. So here, this is the question. So here, in this Honorable Supreme Court judgment, it is clearly ruled no deemed disqualification unless it is on record. So resolution applicants must not be barred based on the assumptions or technicalities, because the view from Supreme Court judgment in 2023, in case of M.K. Rajagopalan versus Periasamy, Palani, Gounder. So in this case, the takeaway is there is no deemed disqualification unless it is on record, unless it is debarred by, unless the order issued by the ROC, Register of Companies, the disqualification order issued by the Register of Companies. There is another view, and this is from NCLAT, latest 2025. So automatic disqualification. So in case of Fortune Chemicals Limited versus Ashok, Kumar, Jaiswal, The NCLAT, Honorable National Company Law Appellate Tribunal, held that a disqualified director in one company automatically renders a connected person or resolution applicant ineligible under Section 29A(e) under IBC. This is the view of NCLAT automatic disqualification. So, a disqualified director in one company automatically renders a connected person or resolution applicant ineligible under Section 29A. Mr. Avinash Kumar Singh, being a disqualified under 164(2)(a) for another company, tainted the resolution plan submitted by Fortune Chemicals. So here the takeaway is the act of non-compliance alone, not the formal disqualification order, is sufficient to trigger ineligibility under IBC. So the act of non-compliance alone, not the formal disqualification order. So the act of non-compliance alone is sufficient, not the formal order. No need to wait for the disqualification order. So the act of non-compliance alone is sufficient to trigger ineligibility under IBC. So this is the another view. This is also the legal view. So now the judicial and policy rationale. Now we will see. See why Section 29A introduced. See the object. See, as per the statement of objects and reasons of the IBC and amendments, IBC and amendments, a person who with their misconduct contributed to defaults may misuse the lack of prohibitions and regain control of the company. So in Chitra Sharma versus Union of India, the Supreme Court emphasized that Section 29A is meant to prevent unscrupulous promoters from regaining control. This is what in Chitra Sharma versus Union of India, the Supreme Court emphasized. Even indirect involvement in a company mismanagement can render a person ineligible. Indirect involvement in a company mismanagement can render a person ineligible. So here, author's commentary or analysis. If we see, the harmonious interpretation is required. The key observations, the harmonious interpretation is required. So it means the both laws aim to ensure responsible corporate governance. But IBC cannot function with the procedural gaps in implementation under the Companies Act. So risk of arbitrary exclusions. Here, the automatic disqualification because he has not filed annual financials and annual returns. So automatic disqualification without competent authorities order can open the door to misuse, delay, and prejudice to legitimate applicants. Regulatory coordination is needed. Like MC and IBBA must work jointly to ensure clarity. A centralized registry of disqualified disqualification directors could help. This coordination is needed. Balance between discipline and opportunity. While 29A protects the creditor's interest, it must not deter genuine resolution applicants based on unresolved filings. This is what. So the final verdict. The law still lacks clear uniformity in this case. So with the Supreme Court favoring procedural justice and NCLAT learning towards strict interpretation. So as an insolvency professional, promoters or corporate advisors, so you must check not only on the legal provisions, but also the judicial mood before stepping into the resolution process. So we are clear. If you found this content insightful, hit like, subscribe, and share this with your networks. For more deep dive into IBC, company law, and landmark judgments, stay tuned to this channel, RR Corporates. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe. Thank you.